there, Legal Tea listeners. This is your host, Jenny Roselle. Well, we are back to the estate planning of the rich and famous topic, where we chat about celebrities and their estate planning. And today's feature needs absolutely no introduction. It is on Michael Jackson. And if you don't know who Michael Jackson is, I don't think we can be friends. You know, old MJ, he had people question him, right? His character, his decisions, etc. And I'm not talking about what side I fall on, what he did, what he didn't do, but I think something we can all agree on is he produced some great music. And I mean, when a song by Michael Jackson comes on, it's impossible not to dance a little bit, right? Or maybe that's just me. So unlike many of the past episodes talking about celebrity estate planning, we've talked about Prince, we've talked about Anna Nicole Smith, we've talked about Larry King. Michael Jackson actually did some estate planning, guys. And so this time we actually don't have to focus on celebrities and their poor estate planning. I'm going to say Michael gets like a B grade-wise on his estate planning. On the surface, his estate plan looks good. He just missed one vital step through the planning process that really hurt him. So let's dive in, shall we? As you may remember, Michael Jackson passed away on June 25th, 2009. 2009 feels like yesterday and forever ago all at the same time. It's so very weird. Michael left behind 3 children named Prince, not to be confused with the other musician Prince. His 3 children were named Prince, Paris, and Blanket. Perhaps it's because this estate stuff is what I do for a living. I always tell people that a solid, well-drafted estate plan is a final and beautiful gift you can leave to your loved ones. So I personally think Michael's kids should thank their lucky stars because their dad took good care of them by leaving them with a solid plan. So what did he have? Well, his estate plan consisted of a living trust, which is honestly a commonly utilized tool that helps to cleanly keep an estate out of the probate court process. Trusts, too, can, if necessary, contain provisions to also gain tax advantages. So him electing to have more than just a last will and testament and have a trust was a super solid move. According to an article on liveabout.com, Michael executed his trust in 1995, shortly before having his 3 children. His first child was born in 97, the second one was 98, and the third in 2002. Then in 2002, Michael completely restated his trust, meaning he made some substantial changes to it. Think of a restatement as kind of like an amendment. So let's get into the nitty-gritty details of Michael's plan. And to give credit where credit is due, the distribution pattern of his plan was provided by that liveabout.com article. I do not have my hands on Michael's trust to provide, to review and provide commentary. I sure wish I did. But anyway, here we go. After the super fun administrative expenses, like taxes, legal fees, medical bills, funeral expenses, etc., 20% of Michael's estate, 20% comes off at the top and is distributed to one or more what's called children's charities to be selected by a panel. And that panel consists of Michael's mother, Katherine Jackson, an attorney by the name of John Branca, I'm not sure how to pronounce that, who was the longtime attorney for the Jackson family. And finally, the third individual was John McClain, and he was a music executive. Michael's trust said that they can choose any children's charities that exist today that support children, or they can establish charities to address, to satisfy this wish. When I say that 20% of the children's charities comes off the top, it's technically something called a specific bequest. B as in Beatrice. So once the expenses are done, 20% of the trust is calculated, and that's what goes to support the children's charities. And then after that 20% is calculated, the remaining balance in his estate is split half and half. So that half and half, 50% of the remaining balance after that 20% going to the children's charities is distributed in equal shares between Michael's children, Prince, Paris, and Blanket. And the other 50% goes to Michael's mother, Catherine. It seems that Catherine's share goes to her what's called outright, no strings attached in my world. She's essentially just going to get a check for her 50%. The kids' shares, however, will be distributed in what are called separate share trusts, meaning that Michael's trust created little sub-trusts for the kids in his own estate plan. And little side note, I do this all the time for clients. So this is not just for famous people like MJ. And, I do it often for, say beneficiaries are young. So like Michael's kids are young. We also do it for beneficiaries that may be battling addictions or maybe on governmental aid. So just know this sort of stuff is not just for people like Michael Jackson. How Michael set up his kids' trust is that the trustees of the trusts, who happened to be that John Bronca guy, who was the attorney I talked about earlier, the longtime attorney of the Jackson family, and John McClain, who was also on that panel I talked about earlier, he was the music executive. So them two Johns are the trustees of the kids' trusts. They're the ones that are running the show. So how these trusts are set up. Prior to turning 21, distributions to the children are completely in the discretion of the Johns. So nothing technically has to come out of the kids' trust before the age of 21. It's completely up to the Johns as to whether they feel that that's appropriate, any money coming out. Then when they hit 21, the kids will receive the income that is generated off the trust assets. And the Johns can distribute more principal, so they can distribute more to the kids within their discretion. So that's what happens when the kids hit 21, and then at 30 years old, the child will get 1/3 of the trust outright, so no strings attached. At 35, they'll get another half of the trust, and then at 40, they'll get the remaining balance. And from my perspective, I love that setup. I love it. It kind of keeps the inheritance from, possibly getting blown. And again, I do this kind of planning all the time for people, and I don't help people like Michael Jackson. A little twist in this, and perhaps an oversight, or perhaps maybe it was intentional, is that Catherine, Michael's mom, is named as the children's guardian. So to get money, Catherine has to ask the Johns, they're the trustees of the kids' trust, for money for the kids. I'm not sure if Michael intended to do this. Sometimes I've seen my clients pick different people as trustee versus guardian to provide some sort of like checks and balances on things. Like if there was solid checks and balances with Jamie Spears, with Britney Spears. I digress. Though if something, it could be something that's overlooked too. I have clients that want the same person in charge of the kids as in charge of the money, just have the same person kind of running everything. Well, everything seemed really great on paper, and it was. What was on paper was good, except Michael made a mistake that so many people do when creating trusts. And what's that mistake, I'm sure you're wondering? When you create a trust, there is a very important process called funding. F-U-N-D as in dog, I-N-G, that happens after the trust document gets signed. And funding is the process that takes your assets and puts them in the name of the trust. So if I have a trust, and say my trust is called the Jenny Roselle Living Trust, my assets would go from Jenny Roselle owning them to the Jenny Roselle Living Trust. So it's just a change of ownership on paper, right? If this process is skipped over, things are still in the, let's call it the human being's name. They're still in, in my name. So in my example, I have a trust, but maybe I didn't do funding. Bad. So my assets are still in my name only, Jenny Roselle. So not the Jenny Roselle Living Trust. And if I pass away, the assets are not in the name of the trust. Those will go according to my will, which has to be probated to get those assets from my name to the trust name. And if a will is getting probated, that means it's a public court process subject to claims including from the IRS. And that's what happened here. So according to a blog by McKinsey Law out of Colorado, Michael left some or all, I'm not sure if it was just a portion of his assets or all, in his name alone. Meaning to get those assets from his name to the trust required probate. A lot of normal, non-famous people create trusts to avoid probate. So if there's something you can learn from Michael's estate, know that if you do a trust, make sure the trust gets funded. It's like trust planning 101. But for some reason, some clients don't fund their trust and their attorneys either fail to explain or maybe fail to follow up with the client to make sure funding has happened. I started to clap. I hope you didn't hear me clapping. I was getting into it. So, tooting my own horn here, my office assists clients with that funding process. And that way, we know T's are crossed and I's are dotted. Anyway, so because Michael's trust was either completely unfunded or maybe underfunded, that meant that there was more work for the attorneys to do. Which, what's that code for? Meaning more legal fees, more work for the executors and trustees, meaning more fees for them. There were probate court filing costs, etc. So really, had Michael's trust been fully funded, the estate would have saved a lot of money. Probably a really healthy chunk of money too. So beyond that, there's even an argument that had Michael's estate not gone through probate, it wouldn't have opened Pandora's box with the IRS either. So after Michael passed away, probate got opened up and the IRS began to question things. And specifically, what they began to question was how the estate's representatives, the Johns, how they were valuing Michael's assets. And just like we talked about in a prior Legal Tea episode when we talked about Prince's estate, the IRS questioned Prince's estate too, Prince's estate representative, I should say, on how they were valuing things too, of course. And if you remember from that episode, they were having to go through probate because Prince didn't have a will. So, of course, the estate of Michael Jackson and Prince too, they have the value to be on paper lower than what the IRS valued things, because the bigger the estate, the bigger the payday for Uncle Sam. So to keep a long story fairly short, Michael's estate representatives and the IRS went back and forth. And kind of, because after all, some assets are kind of truly hard to value. According to a wealth management article, by the way, which has the best headline ever for this article. It is titled Michael Jackson's Estate Moonwalks Past the IRS in Tax Court Battle. I love it so much. So what I mean by this being, assets being hard to value is, like, what dollar figure do we assign to Michael's, quote, image and likeness? What do we assign value-wise? Something called the New Horizon Trust II, which held Michael's 50% ownership in Sony/ATV, which, by the way, owned copyrights relating to a whole bunch of songs from the Beatles, or even New Horizon Trust number 3, which held Michael's ownership in My Jack Music, which had the catalog of copyrights for all songs that Michael wrote or co-wrote. So Keep in mind, these things are not like assets like cash or real estate investments. What the tax court was specifically valuing was this kind of intellectual property stuff. So the image and likeness value, the value of Michael's ownership in both those trusts. So they weren't kicking up a fuss about Michael's, cash value or real estate value. It was just more of that intangible stuff. Initially, the IRS argued that Michael's estate had underpaid estate tax to the tune of $500 million. And because of that underpayment, the IRS was going to assess around $200 million in penalties. These are just such huge numbers. Ultimately, the outcome was actually a win for the estate. The tax court, after the estate and IRS went head to head, stated that the value of the intellectual property was around $5.3 million when the IRS was attempting to claim that all that was worth $482 million. So yeah, Michael's estate kind of won big time. The purpose in bringing all this up, though, is that there's much talk that had Michael actually funded his trust, so put all those assets, even the intellectual property assets, into his trust, his estate would not have gone through probate. And had it not gone through probate, which, like I said earlier, is that public process, the IRS may not have gotten involved and caused this delay and expense to the estate. So what do we take away from old MJ? Well, he did a really good estate plan. He put his wishes on paper. He seemed to keep him updated, hence why he was amending, restating his trust. But where he tripped and fell was that funding aspect. And to be frank, it's among my biggest pet peeves in my industry. I work with a lot of individuals and families that bring in their estate plan for me to review, which their estate plan is done by another attorney. And if they have a trust, I always kind of cautiously ask, what is in the trust? I'll ask about their house, their investments, their life insurance. And the amount of times I hear them say, I don't think anything is in the name of the trust. So hear it from me. Funding the trust is nearly as important as signing the trust on the dotted line. Fact. So that's what we got for old MJ. Next week's topic is a cautionary tale, a real life case I've personally worked on. And it's about a lovely little lady who, when I first met her, she made a lawyer joke, and that's always going to be a thumbs up for me. It was her husband, and the episode really goes over the many lessons you can take away from their situation. So stay tuned for that. And until then, Legal Tea listeners, take care and be well.